My name is Jack Beatty. I'm an editor of the Atlantic Monthly, and I welcome you on behalf of the Atlantic Monthly and the Institute for Politics to this public affairs forum. The subject tonight, as you know, is the debate on original intent, and the occasion for this meeting is an article that appears in the December issue of the Atlantic Monthly on that subject, on the debate on that subject, by one of our panelists tonight. This, as you know, is the bicentennial of the Constitution, and were it not for Attorney General Edward Meese, this bicentennial might be a rather academic observance. But the Attorney General, in some extremely provocative addresses, has saved the Constitution from being pickled in adulation on this, its 200th anniversary, and we will try to unpickle it even further tonight. Our panelists are Senator Orrin Hatch. He's the junior senator from Utah. He's the chairman of the Labor and Human Resources Committee of the Senate, which post he will surrender to his friend Edward Kennedy, the senator from Massachusetts, when the 100th Congress convenes in January. He is in addition the chairman of the Constitutional Subcommittee of the Judiciary Committee. He is the author of the Equal Rights Amendment, Myths and Realities, and numerous articles on constitutional issues. Lawrence Tribe is a professor of constitutional law at the Harvard Law School. Indeed, he holds the chair of constitutional law there. He is the author of 12 books and 90 articles on constitutional law. Most recently, God Save This Honorable Court, a book on the Supreme Court, which received the dust jacket endorsement of his debate opponent tonight, Senator Hatch. Our third panelist is Jack Ray Cove. Jack is a professor of history at Stanford University, where he's the chairman of the American Studies program. He's the author of The Beginnings of National Politics, an interpretive history of the Continental Congress, and of the forthcoming book, James Madison and the Creation of the American Republic. His article, Mr. Meese Meet Mr. Madison, appears in the December Atlantic and is the occasion of our convening tonight. A word about the situation of this debate. As you know, what authors mean is one of the most vexed questions in literary criticism, and certainly in biblical criticism. And it is also a profound issue in constitutional matters. Last year, or the year before rather, Attorney General Meese gave a much reported speech in which he argued that the judges should be guided by what he called a jurisprudence of original intention in making law, that they should be guided by what were the intentions of the founding fathers in interpreting the Constitution and law. His speech and subsequent articles by him and his associates provoked a major debate in which Professor Tribe was one of the participants, and it provoked a notable rejoinder from Justice Brennan of the Supreme Court, who argued that we can't know the intentions of the framers, and even if we did know those intentions aren't binding on us. That the law is a living document, and that it must evolve to meet the changing exigencies of a complicated and indeed increasingly litigious society. And he attacked the Meese position as a case of arrogance cloaked in humility. The arrogance being that the founding fathers' intention should be primary in judges' minds. The humility being that we should be that judges should defer to those intentions. Well, that, in a very rough and ready way indeed, the groundwork of this debate, and the participants tonight. Senator Hatch will speak generally for the Meese position, and Professor Tribe for the position staked out by Justice Brennan. Professor Ray Cove will speak for James Madison as a biographer of James Madison. He knows the original intentions of James Madison about as well as anybody, spending most of his waking hours in the 18th century. And he will try to shed a historian's light on this debate about, after all, the intentions of the primary framer. For James Madison was that. All scholars agree that in the making of the Constitution he was the decisive figure, and so his intentions and his views have an unavoidable centrality. Our moderator tonight is Howard Simons. He's the curator of the Nieman Foundation for Journalism at Harvard. He was for many years managing editor of the Washington Post, and he's the co-author, most recently with Haynes Johnson, of a novel called The Landing. Mr. Simons agreed to moderate tonight's proceedings on shockingly short notice when our scheduled moderator was detained by snow, and we are enormously grateful to him for coming out and moderating tonight's debate. So without further ado, I'd like to introduce Howard Simons. Thank you.
Thank you, Jack. I thought we'd never get to the debate. I'm a designated pinch moderator. All I know about the Constitution is the First Amendment, and that's all I ever care to know. And I like the First Amendment. Thanks to the award-winning Attorney General of the United States, we're here tonight. And on that note, I would like to ask Larry Tribe to begin the debate. Larry?
Thank you very much, Howard. I'm delighted to be here this evening. I'm especially delighted to be here with my friend Senator Hatch. I think you should all know that although there was this dust jacket endorsement by Senator Hatch of one of my latest books, I think he did take a closer look and had some critical things to say about the book in the Harvard Law Review, and I commend his review as well as the book. I'm curious... Especially the book. I'm curious how many of you would be surprised at all at the source of this quotation. It's quite brief. I'd like to read it to you. It is a simplistic view that constitutional interpretation can be limited to the plain meaning of the Constitution's text or to the subjective intention of the framers. The Constitution is not a deed, but a document announcing fundamental principles in value-laden terms, necessarily leaving ample scope for the exercise of normative judgment by those charged with interpreting and applying it. Now, that is not the language of some wild-eyed academic. It is not even the language of Justice Brennan. It is the language of William H. Rehnquist and Byron White in a dissenting opinion issued this June. And I think that should give us some food for thought. I think the lesson is that original intentions are a little bit like motherhood. That is, it sounds awful to be against them. But it's not always clear what being for original intent means. And some of the least likely people have said so. Now, I think it would be helpful if we could look a little bit systematically at the usual argument for a jurisprudence of original intent. It's fairly straightforward. Begins with the premise, which I share, that the Constitution is law, and it is law that necessarily binds all branches of the government, including the judicial branch. It follows that it must mean something beyond what the judges want it to mean. The Constitution is not to be a vehicle for simply wish fulfillment, fulfilling the wishes of the judges who read it. Then it must be a vehicle for realizing the wishes of others, namely the framers, the founding fathers. By focusing on their intentions, we can assure that constitutional law will be objective, that it will be external to the interpreter's own preferences, that it will be appropriately august. That's the usual argument, and it's really hard to fault it so far as it goes. Except that there is an equally plausible argument, often advanced, against a jurisprudence of original intent, and that is that original intent is a snare and a delusion, that it is a mere mirage. First of all, even if there were only one founding father, it would be awfully hard to know what he or she, as it happens he, they were all he's, they were all fathers, what he or she actually meant. I saw a recent item in the Charlottesville Daily Progress in Virginia. I don't make a habit of reading the Charlottesville Daily Progress, but I read the New Yorker from time to time, and they give you these little tidbits. This comes from the Charlottesville Daily Progress. If he were to visit the University of Virginia today, Thomas Jefferson would be pleased. Or perhaps not. University officials really aren't certain. And there is, of course, that problem. It's a little hard to know. The problem would exist even if there were only one framer, but in fact the problem is compounded, for there were many. 55 delegates to the convention in Philadelphia, nearly 100 members of Congress who proposed amendments, the Bill of Rights, lots and lots of people in the state ratifying assemblies, and of course one can pick and choose whose intent, since they rarely converge unambiguously, whose intent really counts. That's the second problem. There is a third problem, and that is there is strong evidence that at least several key framers, and perhaps the framingest framer of them all, James Madison, really did not believe that the specific intentions of the framers, the examples that would occur to them, the particular things they said and assumed, ought to be binding. That's why he didn't, until after his death, authorize publication of his notes of the convention at Philadelphia. Yes, he thought, as did other framers, that the general sense in which the Constitution was accepted by the nation should count, but not a fine parsing of particular assumptions by specific framers. And then there is the further argument that even if the history were otherwise, that is, even if the framers themselves intended to bind the future by their specific assumptions and premises, that would be historically of interest. But it would be hard to treat that as binding, since it was, after all, not their intentions that get ratified when the Constitution and its amendments are accepted. The Constitution is law, after all. It is what the document says, its language, its structure, its general sense, as informed perhaps by intent, but only as informed by intent, that really ultimately counts. And so the conclusion is reached by Justice Brennan, though not, as you will see, necessarily by me, that a jurisprudence of original intent is therefore impossible to carry out, and therefore it must simply be an excuse for a stingy view of selected individual rights, like the rights of women and of minorities and of non-Christians. So now you have both positions. Well, with apologies to Justice Brennan, whose views I'm not here particularly to defend this evening, I think both standard positions in the original intention debate are at least partly off base and overstated. The fact, I think, is that original intent is sometimes reasonably discoverable despite all the difficulties. It is true that original intent can be used as a means to defeat minority rights. For instance, it's simply a fact with which I think Senator Hatch and others who advocate a jurisprudence of original intent must grapple, that those who wrote and ratified the 14th Amendment believed that it would permit racial segregation in public schools, believed that consistent with the 14th Amendment were criminal laws against racial intermarriage, believed that despite the 14th Amendment it was just fine to exclude women by law from various occupations and professions. And I think those who defend original intent have to explain how it is that while defending it, they can nonetheless agree with decisions like Brown v. Board of Education and some of the Supreme Court's decisions dealing with gender. So original intent can be used to defeat minority rights, but it can also be used expansively It's quite clear, for instance, that the authors of the 14th Amendment and those who sent it to the states approve various forms of affirmative action through things like the Freedmen's Bureau for black people. And I think those who advocate a jurisprudence of original intent have to explain how they reconcile their opposition to affirmative action with that jurisprudence. But the point is that original intent needn't be used simply to push down the claims of the downtrodden and of minorities. It need not be a mask, in other words, for a result-oriented conservative agenda. Having said that, I think one has to concede that it is really hard to deny that the idea of original intent, as used by the Reagan administration and many of its friends, has become a kind of code for constitutional interpretations that conveniently track the agenda of the political right on abortion, on contraception, on religion, on affirmative action, and for some, like Richard Epstein of Chicago, on the issue of economic deregulation. And I think it is also quite plain that it's no accident that the metaphor of original intent is chosen. It serves as a source of legitimation. It suggests that there is some neutral vision out there of deference to the patriarchal authority of the nation's founding fathers, in terms of which we can regain a sense of nationhood and community, out of which, however, some may be conveniently excluded. Now, I think our question ought to be, how do we get beyond this ideological shell game? And my answer is to focus on how the illegitimate uses of original intent differ from the legitimate uses. I would identify 6 illicit uses of original intent, and I'm curious about Senator Hatch's response to them. It seems to me, first, clearly illegitimate to use original intent to rewrite the Constitution's text the way Judge Bork does. For instance, First Amendment says Congress shall make no law abridging the freedom of speech. He looks, Judge Bork does, at evidence of original intent and says, well, they really, though they said speech, they meant political advocacy, and they were particularly concerned with censorship of political advocacy, and it's therefore wrong, he says, to use the First Amendment to protect non-political films, for example. That seems to me an illicit use. Second, it seems to me illicit to use original intent to condemn practices that the text quite clearly permits. Recent events suggest one example. I think both Senator Hatch and I believe that immunity should be granted to Poindexter, North, a number of others, in order to force them to testify. I think the language of the Fifth Amendment permits that. But if you were serious about original intent, you would find strong evidence that the framers would be aghast at the idea of compelling someone to be a witness against himself, simply by the device of giving him immunity. I think using original intent in order to condemn the practice of giving immunity would be wrong, and there are other similar examples. Third, I think it is wrong to use original intent to condone practices that the most principled reading of the text would forbid. For instance, racial segregation. Clearly a form of subjugation incompatible with the concept of equal protection. It shouldn't matter that the framers thought it was a terrific idea or entirely acceptable. Another example, clergy disqualification. Jefferson and a number of the other framers thought that clergymen should not be allowed to hold public office. I think a fair reading of the religion clauses would bar that practice. I think the court was right to bar it. I'm curious how those who advocate a jurisprudence of original intent, however, would reconcile that with the fact that many of the framers, some of the most notable, thought clergy disqualification was just fine. Fourth, I think it's illegitimate to use original intent jurisprudence to turn principles into rules. Justice Rehnquist again provides my text. He said about a decade ago, when the framers used general language, they deliberately gave latitude to those who would later interpret it. The Equal Protection Clause provides general language. Those who would read in it a specific hard and fast rule, like no race-specific affirmative action except to make whole the victims of proven race discrimination, the Reagan administration's position on affirmative action, I think have to justify transforming the general principle of equal protection into any such rule. I think that transforming the deliberate choice of general language into a hard and fast rule is an illicit use of original intent. Fifth, using original intent to obscure the constitutional forest by focusing on a few trees strikes me as wholly illegitimate. If you look at the constitutional plan as a whole, it seems to me very clear, evidenced among other things in the language of the Ninth Amendment, that it is designed to affirm a principle of limited government. That's original intent at an appropriate level of generality. But many who advocate a jurisprudence of original intent would cover that up by focusing on the fact that the framers didn't have any specific idea that they were outlawing restrictions on contraception, restrictions on abortion, restrictions on consensual sodomy. That focuses on the trees, misses the constitutional forest, and seems to me illegitimate. Sixth and finally, I think it's illegitimate to use original intent to cover up the need for constitutional argument and constitutional choice. That is, to use reference to original intent as though somehow that could settle the matter and eliminate the need for the hard normative judgments that Chief Justice Rehnquist and Justice White rightly conceded are required. Seems to me at the heart of the Mies agenda, the pretense that it can be a device for eliminating the need for judicial struggle and judicial choice. Now, when you rule out those 6 illicit uses of original intent, you do leave in place a range of quite legitimate and quite vital uses. I think evidence of intent has to be used to shed light on specific terms of art, like the ex post facto clause. And it has to be used to illuminate what Chief Justice Rehnquist again called the tacit postulates of the constitutional plan. Postulates that he's interested in searching out in states' rights cases, but not quite so interested in searching out in human rights cases, cases about individual rights. My greatest concern is that original intent, like other good intentions, will be used to pave the road to a kind of constitutional hell. An oppressive vision of greed in the corporate boardroom, jingoism in the White House basement, and government as big brother in every bedroom in the land. I don't say original intent has to be used that way, but I think the challenge for those who advocate a jurisprudence of original intent is to dispel that danger by moving beyond slogans and joining in the search for criteria to separate sound from unsound appeals to the original intentions of the framers. Thank you.
Now we'll hear from the proto-devil, Senator Orrin Hatch.
Thank you so much, Howard. I've been called many things, but not the proto-devil before. No, I suspect that I must say this, that you make your professors rather short up here, so I have to hold on to this microphone. I'm delighted to be on the same program as Larry Tribe. I've been chairing the Constitution Subcommittee now for 6 years. And I can tell you that we have no more eloquent spokesman in this country on constitutional principles, whether you agree with him or don't, than Larry Tribe. And I have a tremendous amount of respect for him. We differ on a number of items. We agree on a number of items. And we agree on a number of items here this evening. But the respect factor is very high. And I recommend his book to every one of you. It is very good reading, but make sure that after you read it, you read my article in the Harvard Law Review, because that'll give you at least another perspective. But I will say this, it's a remarkable book and written by a remarkable individual for whom I have the highest respect. I was asked this evening by one of my administrative assistants, he said, if you were to choose anybody to argue your case in the Supreme Court, who would you choose? And I immediately said, well, I would choose Larry Tribe if I could get him to do it. And I mean that sincerely. He's a great man, and he's a great mind, and he's somebody that Harvard, I think, is much better for. Let me just say this. Near the outset of our republic, John Marshall stated in Marbury versus Madison that the government of the United States has been emphatically termed a government of laws, not of men. Based on this sound footing, he concluded that the power of judicial review springs from the obligation of the courts to adhere strictly to the actual text of the Constitution. No man or woman, whether president, senator, congressman, governor, or even federal judge, was to be permitted to flaunt the written law of the United States, particularly its foundational document, the Constitution. Now, implicit in this concept is the duty of the judiciary to protect those minority rights recognized within the Constitution. If the judiciary failed in this duty, it would facilitate majority tyranny. The judiciary, however, has an equally, and I might add an equally competing and compelling constitutional duty. It must also protect those portions of the Constitution which authorize the majority to govern dramatically and democratically. If the judiciary failed in this duty, it would then facilitate minority tyranny. So there are two real issues, not just to protect the minority, but to protect the rights of the majority too, as enunciated in the Constitution. This requires judges to continually maintain the balance of the constitutional structure. They must define the bounds of minority freedoms and majority power. Now, for most of our history, this was not perceived to be a great difficulty. Great jurists like John Marshall and Joseph Story, they considered the Constitution to be law, a legal contract requiring special handling and care, but a law which contained the guidelines for defining freedoms and powers. Only in the last several decades, really, have theorists suggested seriously that the courts have the power and the duty to create new freedoms, which are not in any real sense to be found in the Constitution. Now, these theorists generally conclude that the majority protects itself well enough in Congress, and the judiciary must assume the guardianship of insular minorities. This new breed of jurist posits that the interpretation of the Constitution may be impossible in many cases and is inadequate to protect minorities in others. These value-creating theories are generally called non-interpretivism. These theories or theorists suggest that judges must, quote, extract fundamental presuppositions from the evolving morality of our tradition, unquote, or must seek a, quote, fusion of constitutional law and moral theory, unquote, or must protect a, quote, higher law, unquote, of unwritten, quote, natural rights, unquote, or must respond to sublime notions of human dignity, to use Justice Brennan. These various theories ignore the framework of the Constitution and the real duty of the court system. Through the Constitution, our society consents to be ruled undemocratically within defined areas, certain defined areas. These areas are basic human rights beyond the reach of majority alteration. Outside these preserved freedoms, the majority can adapt national policies, quote, to the various crises of human affairs, unquote, to use another phrase from John Marshall. The statutes and policies of the nation are the tools of evolution and adaptation. The framework of the Constitution and the balance that it strikes remains anchored unless changed by the amendment process prescribed under Article 5 of the Constitution. Judges, once again, are not given the responsibility of protecting solely minority rights or solely majority rights. They are to police the balance which should be found in the Constitution. And although this audience scarcely needs it, a quick illustration, I think, may illustrate this process. The First Amendment states that Congress shall make no law abridging the freedom of speech. Individuals thus enjoy at least the freedom to speak their minds on political issues regardless of their views. The balance, however, has to be maintained. No one contends that Congress or state legislatures are forbidden from punishing a spy for speaking to the Soviet Union about our national secrets, or from preventing what really happens to be clear and present danger, or from regulating fighting words and so forth. Let me supply just another obvious example of how this balance can be upset. Article 2, Section 1 states that a person must have, quote, attained to the age of 35 years, unquote, in order to be eligible to be President of the United States. Now, this sounds easy to interpret. Yet a non-interpretivist scholar opined recently that this language should be viewed as a vague recognition of the importance of maturity and could be replaced by 50 years or 30 years without impairing the integrity of the constitutional structure. In other words, 35 does not mean 35, but some undefined notion of maturity. Now, can you imagine the Supreme Court trying to decide whether an individual elected president by the people of the United States is sufficiently mature to govern? And yet that's what he would seem to be saying. Oh, of course, that's a radical statement, but I guess he didn't think so. In another sense, this is an intellectually honest opinion by a non-interpretivist because it demonstrates that if the courts are free to stray from original meaning of the Bill of Rights and the other amendments to protect minority rights, then they are also free to depart from the purpose and meaning of the structural provisions of the Constitution as well. In either case, I would suggest that the court would be improperly deviating from basic fundamental law. Whenever judges depart from the Constitution or adapt the Constitution to suit the times or otherwise tilt the careful constitutional balance, vital rights are abridged. Let me mention a few examples. In one unfortunate case since overturned, the judges decided to strike down a state labor law designed to provide safety and healthy workplaces. Now, judges in this Lochner era invalidated over 200 federal and state health, safety, and welfare regulations. In another instance, judges nullified the capital punishment procedures of 34 states on the basis of personal standards of human dignity rather than the Constitution's cruel and unusual punishment provisions. Although this list might go on, I will mention only one more tragic example. In 1857, judges decided that blacks are not people entitled to the protection of citizenship under the Constitution, the famous Dred Scott case. Now, the rights lost in each of these cases are significant. The first casualty is the right of individuals to make democratic choices. As Lord Chesterton put it, what is the good of telling a community that it has every liberty except the liberty to make laws? The liberty to make laws is what constitutes a free people, unquote. The second casualty is the constitutional power to adjust policies to meet changing circumstances. Once a policy is locked into the Constitution, it cannot be adjusted by simple statute. Thus, in each of those areas mentioned above and others, the people in the states are disabled from making changes to account for, in the case of Roe versus Wade, new medical techniques, for example, or even other evolving circumstances. This means that unelected judges assume the primary governing role in areas that ought to be subject to review and revision as circumstances require, instead of as cases arise. The third casualty is a dilution of the most valued individual liberty of all, the liberty intended to preserve all other liberties, namely the right to vote. Individuals in our republic expect and deserve to have their votes shape the laws by which they are governed. Individuals in the states are disenfranchised from voting on grave and important national questions when judges sweep more and more policymaking within the ambit of the Constitution. Now, Article 3 commits the judiciary, or to the judiciary, the resolution of cases and controversies arising under the Constitution. Accordingly, when one set of rights clashes with another, judges must define the realms of minority freedom against democratic incursion and the realms of inappropriate majority freedom to legislate. This requires construing the balance ordained by the... I'd better be careful here. After all, this is Harvard. This requires construing the balance ordained by the 2,800 or so words of the Constitution. Now, this brings into focus the key question. Namely, what standards are to govern judges when they execute their responsibility of protecting all constitutional rights? To borrow from our First Amendment example, the rights to speak on political subjects as well as the rights to maintain order in courtrooms or to even protect national security. The only place really that judges can look for a resolution of these dilemmas is the Constitution itself, not the subjective intent of a few of its authors, because you see, authors sometimes disagree, not the subjective intent of its ratifiers. Historical records are sometimes incomplete. And certainly, and I might add, I think, more importantly for today's argument, not the subjective intent of contemporary judges, unelected contemporary judges. Indeed, a judge should not look to subjective intents at all, but at the original meaning of the words of the Constitution. I have to admit, I think Larry Tribe hit the nail right on the head when he talked about original intent. I'm talking about original meaning, and I think there is a real and significant difference. Now, on this point, I think the framers would agree. Now, this process entails ascertaining the general understanding of the words of the Constitution. Justice Holmes described that as follows. He said, "We asked not what any single man meant, but what those words would mean in the mouth of a normal speaker of English, using them in the circumstances in which they were used." That sounds pretty logical, doesn't it? Some judges, however, prefer to ask, what do these words mean in our time? Or how could these principles be changed? Now, to that, Justice Harlan responds, when the court disregards the express intent and understanding of the framers, it has invaded the realm of the political process to which the amending power was committed, and it has violated the constitutional structure which is its highest duty to protect, unquote. James Madison further responds, if the sense in which the Constitution was accepted and ratified be not the guide in expounding it, there can be no security for a faithful exercise of its powers. You know, a judge, Justice Cardozo observed, is not a knight errant, roaming at will in pursuit of his own ideal of beauty and goodness. A judge is the figure entrusted with one of our most sacred responsibilities, preserving the balance of the Constitution. This entails discovering that balance as it was generally understood when adopted. It does not entail adopting the views of one or more persons who were present in 1787. It does not entail attempting to divine the actual cerebral gymnastics of those who were present on September 17, 1789. It does not entail reading an expository book, whether of historical origin or of modern jurisprudential theory. It does not entail dubbing some constitutional contours as anachronistic. It does not entail deciding that new contours would be better or provide more protection for minority rights. It does not entail concluding that those constitutional contours must be executed through judicial scrutiny. Ours is a government of laws and not of men. The words of the Constitution were drafted at length and reduced to writing precisely to convey an identifiable meaning. Where it does not convey an identifiable meaning, judges have no law to interpret and are not justified in making new laws. They weren't elected to do that. In fact, they're appointed for life, and that's giving them an imperial aspect that really they don't deserve to have. Now, once again, I think John Marshall put it most succinctly. It is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of courts as well as for that of the legislature. Thank you so much.
Thank you, Senator Hatch. I'm going to ask Larry Tribe if he would like to take 2 minutes of rebuttal, and then Senator Hatch has 2 minutes, and then we'll go to Madison. You can do it from there if you want.
No, brother. Well, I'd be delighted to take Senator Hatch's case if I knew a little more about the bottom line, because it's easy to agree with a good bit of what he said. I certainly agree that rules like the president must be 35 shouldn't be transformed by some alchemy into general principles. But I didn't hear any response to the equally crucial proposition that general principles like that which commands equal protection of the laws, or protects liberty from denial without due process, or protects the privileges or immunities of national citizenship, I didn't hear any answer to the proposition that those ought not be converted by any opposite alchemy into narrow rules. So that when Senator Hatch says that we ought not to create new freedoms beyond those found in the Constitution, I'm perplexed. The word liberty is a capacious term. The notion of equal protection is broad. The concept of privileges or immunities of citizenship is a broad concept. Now, when the court, often guided by Justice Harlan, whom Senator Hatch quoted, discovered in those words the fundamental presupposition of the right to be left alone in the contraception area, for example, I think that Justice Harlan was right not to be deterred by the fact that the framers might not themselves have thought in terms of birth control, and not to be deterred by the absence of any reference to the word contraception in the Bill of Rights. Indeed, the Ninth Amendment, which is law, which is part of the Constitution, quite expressly mandates that the failure of the Constitution to enumerate a specific right shall not be construed to deny or disparage its existence. Any contrary view, and I detect in much of what Senator Hatch says, a movement toward a narrower view of personal rights in order to vindicate what he calls the most basic right, the right to vote, which, by the way, is nowhere mentioned in the Constitution, the right to vote in state elections, nowhere mentioned. Any move in the direction of narrowing these personal rights would have an extraordinary impact on decisions that I suspect, though if I'm wrong, I'd like Senator Hatch to tell me I'm wrong, that I suspect he and I would both applaud. When in the 1920s the court struck down laws in Oregon saying you have to send your child to a public school, laws in Nebraska saying you may not teach your child a foreign language, when in 1965 the court struck down laws saying you may not use a contraceptive, when in 1977 the court reversed the conviction of a grandmother under a zoning code that made it a crime for her to live with her two grandchildren because they were cousins rather than siblings. When the court did all of those things, it acted in the name of fundamental presuppositions of family privacy, marital autonomy, personal dignity, not one of which is expressly mentioned in the Constitution. Now, I would like to know, were the courts that did that illegitimately creating new rights? Or were they, as I believe they were, legitimately filling out the fundamental presuppositions of a system that, to be sure, does exalt majority rule, does exalt democracy, but does so out of an Enlightenment vision of what it means to be a person, the nature of human dignity? Why, after all, is it that it's appropriate, in the view of Chief Justice Rehnquist and others, to look at the fundamental presuppositions of the Constitution when it comes to vindicating states' rights, but to regard it as unduly creative and activist and loose-lipped to talk about fundamental presuppositions when it comes to protecting the rights of individual human beings under the broad, capacious terms of the Constitution? Until I know that bottom line, I guess, Senator, I can't figure out if I will take your case or not.
Well, you see, where Larry and I have our difficulties is not that judges can't be innovative and creative. They are. They have been throughout the history of this country, but especially in the last 50 years. The first 150 years of our Supreme Court history was primarily an interpretivist set of years, although there are notable exceptions to that during that period of time. I might add that Larry indicated that one of the things that he has difficulties with is should not Griswold versus Connecticut have come down, finding a right of privacy, and Roe versus Wade, which found a right of choice in the mother to have an abortion, in essence. Should not those cases have been decided, even though Archibald Cox and John Hart Ely said, and they conceded that the 1973 Roe decision, they said, is not constitutional law and gives no sense of even of an obligation to even try to be. The difference is this. We have in our Constitution a system of separated powers, concurrent majorities, checks and balances. Now, those separated powers are divided into three basic powers. There are other checks and certainly other interesting nuances in the Constitution. But two of those enumerated powers, the executive and the legislative, are elected by the people to enact laws and to operate and to govern. The third, and there are many, many reasons why the third was made the way it was, but the judiciary, these people are not elected to anything. And so the purpose of the Constitution, it seems to me, is to not have an imperial judiciary that decides in and of themselves on any given occasion of their own whimsy to decide what the laws ought to be for you and for me. but that they strictly ought to interpret the laws that are actually established through an accountability process by those who are literally elected to establish those laws. Now, there have to be, it seems to me, some problems in between. Where do you cut the fine edges? And I agree there are problems, and I agree there are almost no philosophical ways of resolving them. But you see, I don't want an imperial judiciary in this country that sets social policy for the country as a whole. And I don't think you do either. Right now, it sounds good to have a Roe versus Wade in the eyes of many people who feel that the woman's right of choice in abortion is a very sanctified right. Now, there are millions in this country who feel that's a very, very bad decision as well. But I don't see anything in the Constitution that gives anybody a right to even privacy, let alone a right to an abortion. And when you come to contraceptives, it may be a very wise thing to allow contraception in our society, and especially within the confines of one's own home, depending upon your point of view. But if I was going to find that, I would surely find it under a public health necessity rather than fabricating a complete new concept of law, just to meet my continuing spiraling demands of fulfilling my duty for you and for me. But that they strictly ought to interpret the laws that are actually established through an accountability process by those who are literally elected to establish those laws. Now, there have to be, it seems to me, some problems in between. Where do you cut the fine edges? And I agree there are problems, and I agree there are almost no philosophical ways of resolving them. But you see, I don't want an imperial judiciary in this country that sets social policy for the country as a whole. And I don't think you do either. Right now, it sounds good to have a Roe versus Wade in the eyes of many people who feel that the woman's right of choice in abortion is a very sanctified right. Now, there are millions in this country who feel that's a very, very bad decision as well. But I don't see anything in the Constitution that gives anybody a right to even privacy, let alone a right to an abortion. And when you come to contraceptives, it may be a very wise thing to allow contraception in our society, and especially within the confines of one's own home, depending upon your point of view. But if I was going to find that, I would surely find it under a public health necessity rather than fabricating a complete new concept of law, just to meet my continuing spiraling demands of fulfilling my own social conscience. Now, the difference is that you can't literally change these judges around. You know, if you view the two cases, and Larry mentioned a number of cases, but let's take the two, affirmative action and Roe versus Wade. I might say that the Roe decision, in my opinion, is not constitutional law. And I think Ely and Cox were right when it says it gives almost no sense of an obligation to try to be. The Constitution has not created any individual right on this subject. And it seems to me that people are and should be given the right to decide those issues in their state and national legislatures. On the other hand, the Constitution has nothing to say about non-discrimination. It says that individuals are not to be deprived of equal protection of the laws on the basis of race. In the words of John Marshall Harlan, the Constitution is, quote, colorblind, unquote. Now, to the degree that a legislature presumes to create a racial quota or a race-conscious preference, it is the duty of the judiciary to declare that act unconstitutional, I believe, under the Constitution. So the Constitution makes those two, it seems to me, those two examples consistent. It leaves the Roe versus Wade case to be decided by duly elected legislative bodies, and of course it erects the inviolable constitutional barrier in the latter case on affirmative action. Now, conservatives can be just as bad on non-interpretivism as liberals. For instance, when I brought the Hatch Amendment, the first constitutional amendment on the issue of abortion, to the floor of either House of Congress, at least as I recall, my amendment was a federalism amendment. It would have left the decision on the issue of abortion up to duly elected representatives of the people in the national legislature or the state legislatures, whichever was the most controlling. The fact of the matter is, I got beaten up tremendously by those on the right who literally want to get 5 members on the Supreme Court who would decide that abortion is unconstitutional under any circumstances and would not give the states the right to make that determination. And by the way, when the Roe versus Wade abortion case came down, there were 6 to 8 states that were moving towards having an indiscriminate right to abortion. So the system was starting to work. It was starting to resolve these issues. And whether you're pro or against abortion, it seems to me it is not right to have an imperial judiciary make these type of determinations when they haven't been elected to do anything. And they've been elected basically to interpret the laws that those who are elected and accountable have formulated and made. Thank you very much.
I'm now going to ask Professor Madison from Stanford to talk to us about his point of view. Jack.
I've been sorely tempted to begin my remarks by recounting, I should say, what Madison told me when he called from Charlottesville to say he was snowed in, wouldn't be able to make it into Logan this evening, and asked me to take his place. More than any of the rest of you, I should say, I am particularly sorry he couldn't be here, because the writing of the biography, on which I've been long delayed by a number of bicentennial projects and other gigs, would be moving much more expeditiously could I only have half an hour or even less of his time. Nevertheless, I take very seriously my responsibility here this evening to stand in for Madison, with whom, as Jack Beatty rightly said, I do spend many, if not quite all, of my waking hours. Let me briefly say that I will try to be reasonably neutral as to the substance of the issues in the contemporary debate. That my basic perspective on this subject is really that of what I like to call a working historian who happens to recognize, simply as a citizen and occasional reader of constitutional law cases and political debate in the larger sense of the term, that appeals to the original Constitution, either its original language or that nebulous, often nebulous, but sometimes some very concrete body of principles that we associate with the framers of the Constitution, is in fact, rightly or wrongly, easily or with great difficulty, very much and inevitably a part of our political process and our adjudicative processes as well. In other words, on particular issues, we may or may not care to appeal to original intent, original meaning, original understanding. Yet nevertheless, there is a curious way in which Americans repeatedly go about this enterprise and repeatedly, in fact, make such claims. And I think one need only refer in our own time to debates over Watergate, debates over the War Power resolutions, as well as the more specifically rights-based controversies of the past 20 or 30 years to see that this is in fact the case. So my concern then is it begins by assuming that appeals to original intent, meaning, understanding, take place inevitably. And we have to ask, and historians in a sense are in some ways better prepared than others, to try to provide the answers, not in the sense that those answers should be prescriptive or dispositive, as the lawyers would say, but simply as part of the information that is necessary that one hopes judges would be able to use, though one sometimes doubts that they can, in fact, but that one hopes judges would be able to use in terms of responsibly going about their enterprise of interpretation by at least having a reliable set of reference points with which to begin. I think that's a reasonably neutral position. I won't try to prejudge, or I won't even intimate, though I think it'll probably become clear, which side of this question I stand on. Well, if Madison were here tonight, what would we ask him? Or in other words, what will I say on his behalf? There are really two kinds of questions we could ask of him. One is we'd like to say, well, what did this provision or that provision and so on really mean? You know, what were you really thinking of when you drafted the First Amendment? How did you define, let's say, an establishment of religion? What does it mean? The phrase advice and consent in Article 2, treaty power, the appointment power, and so on. Then I think is the position that by and large today's conservatives in the current debate would take, or at least that's the question they would like to ask. On the other side of the question, I think the liberals in general, Justice Brennan certainly, I think Professor Tribe as well, would want to ask, look, James, or Mr. Madison, if we're being suitably deferential, Jimmy or Jemmy, although I've never actually encountered that usage. I think that's apocryphal. We'd want to say, knowing what we know and experiencing what we've experienced, how would you apply those principles to the issues that concern us today? I'm going to pass on the second of these questions, the one in a sense that's closer to the liberal position, and I will try to take the historical line and try to ask, I think of both Senator Hatch, I think first, and then Professor Tribe, two questions, which I think will do the best that I can do under these circumstances, to pose the issues as I think Madison would have wanted them, would have wished them to be posed. Now, first, I think I'll address the claim that Senator Hatch has made, the argument against the imperial judiciary and on behalf of democratic decision-making, because I think it is in many ways the central claim that is at the heart of the controversy, or one could say the debate, that Attorney General Meese has launched. I would gloss Meese's position in this way, as I understand it. We will call for a relatively abstentionist or a much more restrained judiciary, which, especially in the area of rights-based litigation, claims of individual and minority rights, will be very cautious, very prudent, very conservative about acting, about creating rights and imposing remedies which are not clearly, demonstrably, explicitly warranted by the constitutional text. The next extension of that position, if one looks at the issues that are of the greatest moment to conservatives, is to say, well, who then decides, who then is making decisions on these issues? And as Senator Hatch, I think, has rightly argued, at least in terms of the implications here, decision-making will then fall to democratically elected legislatures or lesser bodies in the states and in the communities. So, what would our friend, Mr. Madison, my friend at least, I like to think of him that way, have to say about this? My central problem with Attorney General Meese's position here, if one wants to speak in terms of original intent, and maybe I should stop at this point and say, to some extent, Senator Hatch, as the lawyers again would say, or as Dean Ely says, has trumped my position by saying he doesn't really care about intent or understanding, but really wants to focus on meaning. So I take that under advisement, but I'll go ahead and try to restate the position as, nevertheless, I think Madison would have argued it. Most of us are familiar, I'm sure, in this room, and in the higher levels as well, with the argument that Madison makes in Federalist 10, the classic, in some ways, the seminal statement of American political theory. The argument is basically that individual liberties, the rights of individuals and minorities both, will be better protected by responsible national officials or by a responsibly constituted national government than is, in fact, the case at the state level. And there are many, two main lines that Madison adduces to support this argument. One has to do with curing the mischiefs of faction. The other has to do with getting better men, and he means people like himself, primarily into office. But the key thing here, in the sense the starting position for Madison's concern, is in fact the conviction that individual rights and minority rights as well, and he was thinking in both terms, would be most vulnerable, would be most prone to being violated when, in fact, they were left to the will or the whim, the caprice, or the prejudice of majorities within the states. He had particularly in mind, as a kind of case in point, the character of politics in neighboring Rhode Island, at least neighboring us here, which was kind of an absolute model of what a poorly constructed small republic should look like. In some ways, some people would still argue the case remains the same today as then. That I'll say no more on that subject. So, but in a sense, the question I would direct to Senator Hatch on behalf of Madison is nevertheless to ask whether or not, in fact, both in terms of some originalist understanding, if one wants to speak of his intentions, which you may not want to do, but also if in terms of our experience as a nation. And one thinks here, of course, especially, I think, of problems of race post the 14th Amendment, particularly. Whether or not, in fact, the experience of Americans has not tended to confirm more than to challenge Madison's original position. That's to say, I would be prepared to argue, were I debating this more strenuously, that on the merits, perhaps Madison is right, and that, in fact, one still wants to be very suspicious of democratic majorities within, especially as they operate within the states, precisely because, as in his classic argument, it'll be much easier for what he calls a factious majority to form and coalesce and work its invidious will within that kind of context. So I suppose that would be my essential question to you, Senator. Professor Tribe, and this is where I suppose my own position becomes more, in a sense, makes my case more problematic. In the case of Professor Tribe, I find it in a sense more difficult to pose a question that takes issue with his own view quite as explicitly. But nevertheless, I'll try to do it again on behalf of Madison. And I'll recur to the distinction which Professor Tribe referred to, and I think glossed over a bit, and I think is also glossed over a bit more in at least some of his popular writings. Madison, as Professor Tribe has noted, was dead set against the idea that the original intentions of the framers should be of any use whatever in constitutional interpretation. And that is, in fact, one reason why he refused to allow his notes of debate to be published until his own passing. He was, of course, the last of the framers the last, in his own phrase, the last lamp to be extinguished in 1836, 49 years after the framing of the Constitution. So Madison was very much opposed to the idea of using intentions in the strict sense of the term. That's to say, the intentions of the authors as part of the process of determining what meaning there was in the original language. On the other hand, he did insist strongly, and from a fairly early point, at least as early as 1796, and I think actually earlier, that what he thought of as the understanding of the ratifiers should in fact be a restraint upon judicial decision-making, and should in a very serious and very powerful way limit the amount of flexibility and discretion that judges could bring to the Constitution when judges were in doubt about original meaning, and when original understanding might seem to constrain them in the sense that the original parties to the compact might not have accepted the desired result. Judges should defer to the democratic process, or more specifically, Madison argued, to the amendment process. We think of it as cumbersome. I actually happen to think Madison thought of it as being reasonably liberal, at least from the starting position in the 18th century. Now, why did Madison take this position? There are lots of problems with it. As soon as you start to think, I mean, it's hard enough for an historian like myself or any historian, I should say, to make sense of many of the intentions of the framers, who are, after all, a fairly prominent group of men. When we come to deal with the actual ratifiers, those people whose sovereign acts as representatives of the population gave the Constitution legal force, our difficulties are geometrically compounded. There are, for the most part, obscure legislators. Our notes of their debates are terrible. I mean, they're just simply unreliable material with which to work. And I think Madison and others recognized that that was the case at the time. So there are terrific problems there. But there is at least, nevertheless, one nice aspect of this, and it is the aspect that Senator Hatch, I think, especially would endorse, namely that Madison's position on behalf of not moving beyond the understanding of ratifiers is at least consistent with the theory of popular sovereignty. Now, why did Madison take this position? I'll try to explain this very, very briefly and then pose a question which I think does have contemporary relevance. His basic concern, I'm convinced, again as a working historian, was that it has to be understood, I think, especially in the context of the sectional disputes of the early 19th century, which become very serious from, well, one could argue from the 1790s, certainly from the Missouri controversy of 1819 on. Madison's understood very, as any Southerner had to do, that much of John Marshall's jurisprudence posed a very serious threat to Southern interest in slavery, which I'm obviously not endorsing, and to all the states' rights assumptions that played into the constitutional defense of the peculiar institution. And Madison, believing as he did that in a certain sense the Union took precedence over the Constitution, as he says in his final deathbed testament, let the Union be preserved, more than the Constitution. Madison's concern, I think, very much was with the political implications of judicial decision-making. If judicial decision-making going beyond either original meaning or intent or understanding somehow raised such serious political concerns that the polity as a whole might be riven, might be bitterly divided as a result of it, then Madison felt judicial discretion as a political act was especially called for. Now, in the contemporary context, one could say, of course, that we no longer worry about disunion. The Civil War solved that problem. But one might want to pose the question, at least, let's take the most sensitive, the most difficult, morally the most troubling issue of all. That's to say, the issue of abortion. One takes this issue and one argues that, people of goodwill and so on are terribly divided over this issue and probably will remain so indefinitely, independent of the substantive merits of Roe v. Wade and all the later decisions. One might argue then, I'll try perhaps speak to some extent on behalf of Senator Hatch as well as Congressman Madison. Might one argue then, Professor Tribe, that in the interest of let's say the underlying community and consensus that must inform a Republican polity, where in fact obedience to law rests not on the coercive power of the state, but really rests upon our confidence in the entire political decision-making process itself. Does this create conditions consistent with Madison's original political understanding in the sense in which I've tried to work it out? Might this create conditions which should in effect call for greater judicial discretion? Given, I think especially, maybe just a kind of a final twist to this point, if in practice, as we see, the court itself is politically divided on many issues, and if the process of appointments itself becomes highly politicized, as in fact it has been, and as you particularly have argued in some ways against, and perhaps in some ways in favor of, under these circumstances, does that not create further problems with which, if we're concerned with those problems, does not the conservative position have perhaps greater merit, even if it means allowing Democratic majorities to impinge upon rights that we would, and some might perhaps want to attribute to individuals or minorities? Thank you.
I don't know if Professor Ray Cove expects an answer from Larry Tribe, but I don't, because if I did, there would be no time to hear the people. I'm going to use the practice of original authoritarianism. Short questions, no statements, direct them to a specific person, and there are 4 microphones, 2 up on top, 2 in the bottom, and if you do start to make a statement, I'll just cut you off. That's original authoritarianism. Way up.
Sorry that to some extent this is the kind of a statement, but I will try to make it as short as I can.
No, question.
Let me share some observations I have from...
I'm sorry, there's not enough time. We have a lot of people want to ask questions. We only have 15 minutes. If you can ask a question, fine. If not,
I will frame
give someone else
in
a
a kind of a question. I get the impression from an outside perspective as a foreign lawyer who saw all this ink in this discussion about non-intentionism, intentionism, perfectionism, that the underlying concept of the way how texts work might be wrong in this discussion. I have to illustrate that idea, what I mean by that. If you take a novel, if you read a novel, you see a scene, you have a hero, we can call him at M, for example, if we like to. Then you have a certain idea of the landscape, and you have a certain idea of the action of the hero. And you will agree that this...
I'm going to cut you off in 2 seconds unless you ask your question without an illustration.
In that case, I stop.
Okay, fine.
Patch. In the light of the original intent pertaining to senatorial endorsement, approval of Supreme Court nominations. In the recent 2 moves, Rehnquist to Chief Justice and the nomination of Antonin Scalia, many people criticized the Senate Judiciary Committee for asking questions about what the justices feel about certain issues or how they might rule. And it was generally accepted by Rehnquist and Scalia that they didn't have to answer any questions pertaining to items that they might later have to rule on. How would you view the original intent of the Constitution as far as the role of Senate approval of judges? Does the Senate, in fact, have a duty to question the political orientation, the views of nominees, or are they bound purely to judging their credentials? And I would argue that that original intent would allow a broader review of an individual's credentials.
Those are very good comments. And as one who sat through almost every hour of both of those nomination proceedings, I think that any senator can ask any question he wants, no matter how dumb it may be. And we sometimes really ask some pretty dumb questions. But the fact is that it was only a few years back where nominees to the Supreme Court even appeared before the Senate Judiciary Committee for confirmation hearings. They have now become a matter of habit, and they will appear. But it is a constant practice for them to just say that, look, I would prefer not to answer that because that case may come up before the court, and I would not like to have to give my opinion about it at this time because I would like to be able to reflect and make a final determination later. They have been able to get away with that. On the other hand, I could understand where Senator DeConcini and others got very upset about it, because how then can they figure out what is the judicial philosophy of a particular nominee unless that nominee expresses himself or herself? Now, I don't think we can force them to talk about issues that may be future issues before the court. But nor do I believe that a confirmation proceeding is going to give us all the answers about a person's judicial philosophy. For the most part, somebody like Rehnquist, who had 15 years on the bench, had written many, many decisions. Of course, 200 of his decisions were reviewed by the American Bar Association. 50 Supreme Court lawyers were interviewed, 80 top law professors throughout the country, 140, I think, or 175 of the top judges, including most chief judges and Supreme Court chief justices throughout the states, were interviewed. I think his judicial philosophy was pretty well known. Actually, I believe Justice Scalia's philosophy was pretty well known. I think it would be better if we could get them to talk about their judicial philosophy, but I think it's an exercise in futility, because even though those hearings could go on for a week or 2 weeks, you still are never really going to be able to dent the surface of all of the myriad of issues that can come before the Supreme Court. The only person who could possibly even ask all of those questions is Larry Tribe.
Just to follow up,
or James Madison.
Wouldn't the original founders view that as a circumvention of the appointment?
No, they would
basis?
not. You're not letting them.
Senator Hatch, as I recall, the Constitution doesn't say very much about the judicial branch, because the framers didn't really have this more modern fear of a judicial imperium that you've articulated.
Well, that we see every day. That we see through these last number of decades.
Now, I'm wondering, though, how then you can make an argument based on the original meaning of the Constitution, which would, with the purpose of limiting judicial power. Are we to take your suggestions as simply not based on the Constitution, maybe some sort of policy concerns, or do you in fact make a constitutional argument?
Well, actually, the Constitution is fairly clear on what a judicial system should be, and it's not so clear in some ways. Fact of the matter is, the Constitution lays down basic underlying principles that literally have to be reviewed. I'm not as caught up in original intent as some of the so-called interpretativists are. I believe we ought to look to original meaning, and I believe that that meaning basically constitutes basic principle, and principle that literally can be utilized, and has been, I think, under this very important Constitution, utilized in both modern and 18th century times.
Senator Hatch, I noticed that quite a few eyebrows were raised when you said that the rights to privacy and contraceptive were not mentioned or guaranteed by the Constitution.
No, they're not.
I was wondering what your response would be to the argument that those are exactly the kind of rights that were guaranteed under the provisions of the Ninth Amendment.
Well, actually, I don't believe they are guaranteed under the Ninth Amendment. The Ninth Amendment basically was a rule of construction for the Bill of Rights. Actually, what the Ninth Amendment really says, in my opinion, is that if you have to determine what rights are, you don't do it by fabricating out of whole cloth through the judicial system by having one or more limited number of judges make up what those rights should be. Those rights should be determined through the constitutional process, really basically through the legislative branch. If the legislative branch oversteps or understeps what really should be a basic fundamental right, then the court can step in and interpret that overstep or understep and say, this has to be changed. That's all the Ninth Amendment means. It does not open up a complete new right in the judiciary to create rights out of thin air. There's nothing mentioned in the Constitution about a right of privacy. Like I say, if I was on the Supreme Court and I wanted to find the same holding as the Griswold case, seems to me I could do it under a public health theory that literally would fit within the Constitution itself, rather than fabricating a whole new theory of law just out of whole cloth.
I'm going to exercise the right. I'm going to exercise the right of the moderator and let Larry try to say something.
Sure. I have to confess, I've been chomping at the bit a little to address some of these matters. I most recently read the Ninth Amendment at about 6 o'clock tonight, and I guess I just don't. Maybe I'm reading a different language from the senator, but it says quite explicitly that the enumeration of certain rights in the Constitution shall not be construed to deny or disparage the existence of others. This is a case where James Madison, were he to have made it in his very long flight from Virginia, would have had something quite helpful to tell us, because the history of the inclusion of the Ninth Amendment was quite explicitly designed to deal with the argument that I've just heard Senator Hatch make. That is the argument that if you can't find a right mentioned in the Bill of Rights, you oughtn't to go around and find it implicitly elsewhere. That was the argument many made against having a Bill of Rights at all. Madison said, you've got a good point, so we better deal with that problem by including a Ninth Amendment to deal with unmentioned rights that might fall between the cracks, like rights of conscience, he said, not mentioned in the Constitution. It is quite clear why the Ninth Amendment was included. It was included not to generate an imperial or whimsical judiciary, which I would join Senator Hatch in criticizing, but rather to demand of the judiciary that it search for the fundamental presuppositions of personal dignity in a free society in ways that do not simply stop by looking at the specific words of the Bill of Rights. And I would think that creating a so-called public health rationale for Griswold v. Connecticut would be far more creative, activist, far out than anything I could imagine urging a court to do. Public health is a matter within the jurisdiction of states and localities, and to the extent it's a matter of interstate commerce, of Congress. The basis for Griswold v. Connecticut is that the right of privacy is implicit in such protections of the Constitution as the protection of the privacy of the home. The Constitution doesn't make sense without some such right. And it seems to me that to run away from that because, for example, the decision will be controversial, or to answer James Madison because the needs of union might require courts to go slow, seems to me to be a fundamental and profound confusion. Yes, an argument might be made that when defending fundamental liberties, like the liberty of a woman to control her own body, something that I would imagine would be on any very short list of liberties, bodily integrity, there's a strong argument that courts ought not to go whole hog and create trimesters and a whole elaborate superstructure. But what was at stake in Roe v. Wade was a woman who had been subjected to a gang rape. The question specifically, and I think the court might have done well to limit its first incursion into this area to be modest, the question was whether it denies a fundamental liberty, or indeed equal protection of the laws, to force that woman to remain pregnant when men, for example, are never forced to make a similar bodily sacrifice even to protect their own children. Now, someone who says that's not a legal question, someone who says it's not constitutional law to answer, it seems to me to be guilty of a very fundamental confusion. You can disagree with the precise answer or with how far the court went, but to say the answer is we should throw it back to the states raises a fundamental problem. I don't think it raises the problem that Professor Ray Cove asked through James Madison. That is, I don't think the problem with sending it back to the states is that Madison feared the states as the central locus of faction. That was an interesting fear, but he lost on that one. The Constitution does preserve the integrity of states in a variety of ways. I think the problem with throwing it back to the states is that in the name of going slow, that entails utter judicial abdication. That is, the question has to be answered, does it or does it not deny equal protection of the laws for women in circumstances like that in Roe v. Wade to be forced to remain pregnant? Now, for a court to say, gosh, it would be awfully controversial for us to tell you what we think about that, let's see what each state thinks, would invert the lessons about union and the Constitution. It was Lincoln who reminded us, one more second, it was Lincoln who reminded us.
This is the second debate.
That the nation cannot long survive half slave and half free. There are certain fundamental issues that cannot be decided differently by every state and every locality, and the ultimate meaning of privacy and equality, I think, is among them.
Well, first of all, Larry Tribe made my point. All right, wait a minute. With regard to the Griswold case, I would not have found, in any event, I would not have found a decision in that case because I would not have found, even under public health purposes, but at least I would have had some basis in the Constitution for making the decision. I still think that that's why the Constitution is written the way it is, and that's why we have the separated powers. If there is an imbalance, or if there is a wrong, or if there's a right that is being violated, then we have all kinds of ways of elevating those rights without having unelected people who are not accountable decide what those rights should be for you and me. That's why we elect people to the Congress. And I suspect that if Larry Tribe was a member of Congress, he'd be the foremost advocate for congressional powers and the congressional right to make these determinations. And I have a great opportunity for Larry, because in 1988 there's a Senate seat up here in Massachusetts, and we'd love to have him run on the Republican ticket. Now, let me just add this other. No, I'm not going to make it quick. Let me just add this one thing on Roe versus Wade. On Roe versus Wade, even the Supreme Court did not go to the Ninth Amendment to justify the decision in Roe versus Wade. It went to the Due Process Clause. And frankly, the Ninth Amendment is very important, but basically what it says, as far as I'm concerned, is that the judicial system cannot just fabricate laws in and of itself. If we had a judge go out and write a statute, for instance, all of us would be offended by that. And yet that's what's happening every day in some of these courts. By judicial fiat, they're writing and rewriting statutes to fit their own ideas of social conscience. And let me tell you something. That sounds good to those of you who are liberal today because of some of the decisions that have been rendered over the last 50 years. But President Reagan, by the time he retires at the end of 1988, will have appointed 50% of the total federal judiciary. And he is looking, through Ed Meese and others, for interpretivists, not non-interpretivists. Now, if that happened to turn the other way, I don't believe it will. I believe that good interpretivists are going to find and uphold basic, sensible rights of people as well. But if it happened to turn the other way, you're going to be just as upset about an imperial, unelected judiciary as a lot of the interpretivists are today.
Senator Hatch, if a Supreme Court justice were to state explicitly, say to a journalist, a New York Times reporter...
What's wrong with the Washington Post?
Washington Post. Given this question, that'd be interesting, too. If he were to state explicitly that in his trying to understand the meaning of the Constitution and in writing up his opinions, that he relies on religious inspiration and prayer, and then the next day this were to be published, would the Congress look upon this as a church-state problem?
Well, I don't know about the Congress, but I know there would be a lot of journalists throughout the country who would explode that particular idea all over the front pages of the newspapers. I suppose that there have been... although it may seem highly unlikely to some of you, there have been Supreme Court justices who do rely on prayer to a great deal and to a great extent. And I hope there are some today. But if they are placing their own concepts of religion over what really the Constitution's basic meaning is, then that would be just as wrong as those who are fabricating statutes, in essence, out of thin air.
Just the fact that it's stated specifically that he does rely on religious inspiration and prayer, for that to be heard by the members of Congress, wouldn't you think it would make them...
I don't think it would make any difference, because members of Congress aren't going to have much control unless they want to impeach that justice.
We've run out of time, unfortunately. I was hoping we could go a little longer because we started a little late. We can? Oh, terrific. Way up. Make it short, please. And
it's very short. Senator Hatch, I'm very interested in your idea that judges should look for the meaning of the words used in the Constitution. You said that they should look at the general understanding of words that a normal speaker of English would... well,
that's what Justice Holmes said.
My question is, just in general, what kind of historical methodology would you propose that we use to understand what the normal speaker of English in late 18th century America would understand, the words such as liberty? Would you look to the framers of the Constitution? Would you look to... and how would you get documented evidence of what, for example, a slave in the antebellum South would think of such words?
Well, those are very good points. That's a very good question. The fact is that I would look to the underlying principles in the Constitution first. I would not ignore the intent of many of the framers. I would look at those. I mean, they deserve to be considered. I would look at the historical context. I would look at almost everything I could, the legislative context in the civil rights bills of 1868 and thereafter. They're all important. But the most important aspect is the actual meaning, the actual underlying principle that was intended at the time that the legislation was enacted. And I think if you look at the Constitution, the reason it is so great is that those principles really do come through even in our modern age without the necessity of judges fabricating their own ideas and imposing their own ideas of social conscience on everybody in America.
So you would advocate looking at 18th and 19th century dictionaries?
No.
VCRs.
No, but no, I wouldn't.
Yeah, my question is directed, I guess, both to Senator Hatch and Professor Ray Cove. I would like to know why it is they would ask the judiciary to apply the Constitution, a method of interpretation that both of them seem to be incapable of applying to the Constitution or to James Madison. My illustration would be Senator Hatch seems to find in the Ninth Amendment, much to my consternation as well as Professor Tribe's, a principle against an imperial judiciary, since he admits he cannot find it in Article 3, which seems rather loose.
Well, I think we find it there, too. Sure, I think it's there.
Well, come on. And the other half of the question would then be how Professor Ray Cove finds in James Madison's deathbed salutation something about preserving the Union overall, which he allows to trump Federalist 10, which is concerned with the rights of minorities, even while he admits that he himself has to rewrite Madison's concern about factionalism to bring it up to today's standards. If everyone's willing to rewrite their understanding of the document or those who wrote it in terms of today's problems, why shouldn't the judiciary?
Well, let me take a little bit of a crack at that. You know, when I talk about talking about original meaning, or the words in context, not original intent, I'm talking about what judges do every day. They interpret wills, they interpret contracts, they interpret statutes, and they actually interpret them in accordance with the express language of those documents. I think the Constitution deserves the same, too. And the very purpose of committing the Constitution to writing, the reason it was so debated, was so that they could get definite, fixed purposes into the Constitution and principles into the Constitution. And they wanted a fixed and discernible meaning. Now, because it is only 2,800 words, or more or less, naturally there are many things that are not fixed and discernible. I might add that, by the way, I commend Dr. Ray Cove's article to all of you in the December issue of the Atlantic Monthly, because I think his article falls into the same trap sometimes. He looks at Madison as the principal expositor of constitutional meaning. Now, I admit he was one of the more influential craftsmen in the convention and in the first Congress, but he was only one member of those bodies. And I might also add that much of what he recommended was rejected as well. He wasn't totally faulted. And if I may nitpick for a moment, just a little bit longer about Mr. Ray Cove's article, I think it will demonstrate just how our modern judgments of past subjective intent can themselves be very subjective. Mr. Ray Cove, he comments that, quote, almost certainly Madison would find nauseous the current conservative claim backed only by the most tendentious and selective scholarship that the First Amendment permits non-discriminatory federal support of religion. Now, this comment, I'm sure, is based on the fact that Madison, as a state legislator, introduced at the request of Thomas Jefferson a bill that disestablished the Church of England in the state of Virginia and promoted religious liberty. Now, it's interesting to note that on that very same day, Madison introduced a bill to punish Sabbath breakers under Virginia civil law. Now, Mr. Ray Cove's comment is probably also based on some of Madison's comments in his advanced years, and many years after his public life, that suggested the merits of a complete separation of church and state. That may or may not be something that we should say is binding on people who are interpreting the Constitution. So it's interesting to note that as a member of Congress, Madison voted for funds to pay for a congressional chaplain, for federal support to religious schools in the territories, and that as president, Madison signed bills acknowledging days of prayer and thanksgiving. Now, I don't know that by these very facts that they present all of the innermost thoughts of Mr. Madison. I think they are basically irrelevant to a constitutional debate. But it is important to realize that our modern view of history may be somewhat narrow and can on occasion be very narrow. So we can't always define those matters the way we want to just because somebody was important in that day and age.
Professor Ray Cove?
There are two sets of issues here, those posed by the questioner and those posed by the senator. As to the first, I'll simply say that try to repeat my starting position, which is that I have no problems finding inconsistencies or difficulties with James Madison's position. That's one of the nice things about being an historian. In a sense, you take the evidence as it is, and you don't have to. You try to reconcile it as best you can. But if Madison was confused or, in a sense, wrong, or if his ideas were not well matured, if they changed over time, if they were problematic, that's fine. I happen to think many of Madison's ideas were problematic. My concern in the article, and I suppose my general concern in this forum, is to say that as opposed to the various claims about original intent that I've seen bandied back and forth, in the debate, especially that's been on since Attorney General Meese's July 1985 speech, it seems to me that very little attention has in fact been paid, except in the most passing way, to the real kinds of difficulties that arise when in fact one tries to make sense of original intent. So I think in a sense you attributed me a political position which is not there. I'm simply trying to explain. I mean, my feeling is that I suppose I'd be prepared to argue that in fact it would be useful for judges or legislators and presidents to try to start by understanding the difficulties, because the difficulties as well as the principles are part of the political system under which we operate. Now, so Senator Hatch has taken exception to my characterization of Madison's position on various things, and he's pointed to some pieces of evidence which seem to cut in the opposite direction. What I'll say to this is that I'll simply repeat the claim and steer both the senator and I think the audience in general to Leonard Levy's, who certainly are far and away our most distinguished historian of the Bill of Rights in general, a recent book on the Establishment Clause, which I think does, on a kind of point-by-point basis, convincingly refute most of those quote-unquote items of evidence that in fact conservative scholars have adduced. And I'll go beyond that and say, more specifically, that anyone who reads Madison's 1785 memorial against religious assessments in Virginia will find there stated a rejection of any notion of church establishment, non-preferentialist or otherwise, so profound, so sweeping, I would argue so moving, that the attempt to link him up with some of the measures that ideally non-preferentialists might want to do so, I think simply fails of its own weight. And I just one kind of further addendum to this. Now here is a case in which I'd be prepared to argue, in fact, looking at what I regard as the great intellectual power of Madison's position, that in fact we can still profit in a normative sense by trying to understand in a fairly detailed way, as I think we can on this issue, some of the concerns that entered into at least his thinking, and as he said about introducing what becomes the Establishment Clause in the Constitution.
When I was drafted for this moderator job at the exact same moment that Larry Tribe was reading the Ninth Amendment, I was instructed that we had to really end by 9 o'clock. It's now 9:15 almost, and I'm going to end it. I would like to thank Jack Beatty, Larry Tribe, Senator Hatch, and Ray Cove. And I'd like to thank the founding fathers of us all.